Hi, Cora Stack here again. Sorry for that interruption there. I just wanted to talk about other options for dispute resolution. I'm very interested in conflict resolution because I think there's so much conflict in the world. There should be a lot more emphasis, I think, and the research on, what conflict resolution, and negotiation, arbitration, all that sort of thing. I think there's too much litigation in this dispute. It's full of litigation, which has resulted in huge escalation and far too much little emphasis on de-escalation, which could have resulted from arbitration being part of our justice system. And this idea I have is that designs a justice system which heals rather than escalates or divides or harms. So in many jurisdictions, particularly in Scandinavia and places like that, this dispute would have first gone to independent mediation and arbitration before suspensions, before injunctions, before prison. Now, my research looks at bringing in a human dimension into the whole system that's currently in these countries, an extra human dimension that understands, the human element of conflict. That every conflict, there's a lot of power imbalance in a lot of conflicts, and behind power imbalance there's a human side of things, people's different personality styles, types, all of that, and you have to kind of factor in all that and understand all the different types of personality presentations. You have to understand people who are very manipulative, very controlling. How to bring that down, how to neutralize it, how to factor all of this into the dispute resolution. So, what arbitration or mediation could have offered in this particular case, which is, it's a huge case, but I think, if anything, it suggests the dire need for arbitration to be introduced in Ireland for dispute resolution, but also for it to be trauma informed and to have a significant human dimension, which is absent from the court system at the moment. Not only that, the balance, it's always a win-lose, so it's never evening, balancing the power. The power goes one way or the other, and in itself entrenches the power imbalance, whatever way it is. It turns it around, but it doesn't even it. It doesn't balance the power. You see the scales, but you never see them even, do you? You always see one going down. It's very good that way. So a neutral forum, not the school disciplining an employee, but an independent professional listening to both sides. It's great to meet a judge in a court that listens, because a lot of people find listening very difficult. They just can't listen. They just haven't got the skills. It's part of the human. Some people just have no listening skills at all. They're very, very impatient, can't listen. They just can't take the pain of the other person. They can't listen to it. They just haven't the skills. The empathy skills. So you'd have to have a lot of empathy for this kind of arbitration. Safe handling of conscience and safeguarding. The school's safeguarding obligations and the teacher's religious beliefs could both have been examined without humiliation or coercion. Practical outcomes the court system can't design. Conditional return, redeployment, agreed conduct boundaries, dignified exit, minding undertakings. None of these outcomes require prison. All of them require dialogue, sitting down, negotiation, listening, talking, in a safe environment, without, the escalation, the media, and the big thing mushing out of all proportion. Why this option doesn't exist in Ireland? Ireland does not mandate early mediation and arbitration in school employment disputes, or indeed in family law disputes or other disputes where, in my opinion, it's urgently needed. Once internal discipline begins, escalation is almost inevitable. Key failures: no compulsory early arbitration or mediation, no trauma-informed process, no proportionality review. Courts used as last and first resort. So that's the important thing. They're not just used as last resort, they're used as first resort. This is not about one judge, one teacher, or one school. It's about a system that defaults to punishment when resolution was possible or never. That was never the first vision of how to resolve this conflict. How do we resolve it? It immediately defaulted to the court system, which is punishment, win or lose, black or white. Even now, resolution is still possible, but only if institutions step back from enforcement and return to dialogue. Options: binding mediation by a retired judge, senior arbitrator. Again, these would have to be very empathetic. They would have to have high empathy skills, or have people working with them with very high empathy skills that are skilled in in dealing with manipulation, or people of a black and white, very black and white mentality. That kind of thing. You really have to look at the different personality styles and how to bring them to a more collaborative state of thinking. That it's not about winning or losing. It's about trying to solve the problem rather than winning or losing. So it's about resolution rather than this winning or losing system that we now have, black and white binary system, which is not suited for many dispute resolutions, and in particular for family law, in my opinion. And many other related disputes where there are a lot of issues around power imbalance. So the other options that could have been considered here, but we don't have them in the Irish system, are binding arbitration, which might involve a retired judge or a legal person who has decided to become an arbitrator, or others, senior arbitrators, time-limited appeals process, negotiated separation with dignity, clear policy reform for future cases. So what the final message here is that years of trauma were not inevitable. They were a result of a system that had no off-ramp from conflict. The case could change how Ireland handles schools dispute. This case could change how Ireland handles school disputes, not repeat them. Call to action. If you believe disputes should be resolved before they reach prison cells, share this video and ask why Ireland still lacks early, independent dispute resolutions in schools and in many areas of dispute where there are disputes in families, for children, for family law, for every kind of dispute you can think of. Why are we so far behind in lacking arbitration systems for resolving these kind of disputes? And if you so that's the question. So if you believe disputes like this should be resolved before they reach prison cells, please share this video. And it's not just those kind of disputes. There are so many of these disputes where the arbitration system could have done so much if it's properly designed to help all sides reach an agreement which would have a more of a healing justice rather than a harming justice in its design. So that's that's what a lot of my research. Well, I do research in a lot of areas, but that research is certainly resonating with a huge amount of people. There's a yearning for a new type of justice, a justice that heals rather than harm, based on affordable justice called trauma arbitration, first mandatory before court.